Hello, everybody. We're glad to have you join us. This is part two of our Worksite Preparedness webinar series. I'm Kimberley Robidoux, partner with WR Immigration located in our San Diego office. And I'm also currently chair of the American Immigration Lawyers Association Verification and Documentation Committee, which is a long way of saying that I live and breathe the I-9s and E-Verify compliance. And I'm here today with my wonderful partner, Carrie. So, Carrie, I'll let you introduce yourself.
Thank you, Kimberly. Hi, everybody. I'm Carrie Koski, and I'm with WR's Denver office. And um, while Kimberly is the chair of the American Immigration Lawyers Association Document Verification Committee, so literally living, breathing, sleeping, immigration investigations now. It's also a large part of my practice as well. So, Kimberly and I work together a lot on these issues for the firm.
So, the typical legal disclaimer, what we're presenting today and talking about does not constitute legal advice. It's for informational purposes only. And if you have any specific legal questions, and if you're a client, please reach out to us. We would love to be able to help out. And if you are not and would like a consultation, we're here to help out as well. Okay. WR Immigration, we journey forward with our clients and with our casework. And we have 10 offices, mainly in the US and one abroad. We also have 180 professionals and we have amazing technology that's rapid, which is our case management system. So we use that in order to help our clients journey forward. Before I get into the roadmap, I'm just going to plug our next webinar in this series will be April 15th. Carrie, I just realized it's tax day. So April 15th, we're going to talk about more information on I-9 compliance, E-Verify, notices of inspection, and any amazing tidbits that I may come away with from our American Immigration Lawyers Association spring conference in DC, in which we liaise with and have panels with those government individuals who are in the compliance area. And so we'll be happy to share anything that's going to be relevant and helpful to employers.
At that conference, your co-panelist is at DOJ, right? So you'll likely have some good takeaways directly from DOJ leadership.
Yeah, we should hopefully have immigrant and employee rights section from DOJ involved in that panel. Yeah, fingers crossed. We know how things keep changing with the administration, but we're looking forward to that.
And we'll send that link out to register after the webinar. Again, it's April 15th.
All right. So today, our roadmap, we're going to talk about IER investigations, FDNS, DOL, and SEVP audits. And so, with that, we're going to move on and just talk initially about our relevant agencies. So, the relevant agencies, when we're talking about these particular worksite actions, is the U.S. Citizenship and Immigration Services, their Fraud Detection and National Security Directorate, which we just refer to as FDNS. It's much easier to say that. So, FDNS detects, deters, and administratively investigates immigration related fraud, typically with regard to H-1B and L-1 site visits. We're also going to talk about some actions that are taken by the U.S. Department of Justice Immigrant and Employee Rights section of the Civil Rights Division. They oversee the enforcement of the anti discrimination issues associated with the I-9 and E-Verify processes and programs. The third agency is U.S. Immigration and Customs Enforcement Homeland Security Investigations, HSI. So they enforce the policies, the rules, and regulations related to the completion of the Form I-9 and E-Verify program. And then ICE also oversees the STEM OPT extension program. And last but not least, the U.S. Department of Labor, which enforces compliance with H-1B labor condition, application public access files, the perm labor certification audit files, and then H-2A and H-2B programs. So a lot of agencies involved in worksite compliance. One of the things that kind of got us started on this series is the executive order, one of the big ones that came out in the beginning of the Trump administration. And so that executive order that we're talking about is titled Securing Our Borders. And what this does is it allocates additional resources toward enforcement. So increase USCIS, FDNS site visits, increase Department of Labor investigations, increase notices of inspection in order to ensure compliance with respect to that I-9 form. ICE raids, which we haven't really seen any happening yet, knock on wood, and then the anti-discrimination investigations by IER. So some of the things that, we're recommending for HR and global mobility teams is to audit regularly to make sure you're prepared in case ICE comes knocking on the door for that I-9 notice of inspection, update policies, or, just review them to make sure that you're staying on top of new federal requirements and any regulatory issues. Train your staff so that they understand how to handle site visits should they occur at your work site, and then also support employees, right? Provide resources and open communication so that everybody is in tune with what's happening and can work together in the event that there are any on site investigations. Okay, so we're going to talk about worksite enforcement actions. And the first on our agenda today is with respect to the STEM OPT extension. So ICE has their SEVP enforcement actions, and SEVP stands for Student and Exchange Visitor Program. So as you can see, lots of acronyms with what we do. So let's talk about the CVP enforcement actions first. Right, so ICE officers from the SEVP unit usually conduct site visits that are related to the STEM OPT extension, right? So that STEM OPT extension is the extension after the first 12-month period of optional practical training for F1 students. And individuals that in F1 status may obtain an additional 24 months of optional practical training, provided that they are employed by a company enrolled in E-Verify and that they submit an I-983 training plan that governs the STEM OPT extension. So one of the things that is really, really critical is that this STEM OPT extension training plan has to be accurate before it's submitted to the designated student officer at the university. The plan is not submitted directly to the immigration service, but rather to the DSO at the university. And one of the things that a lot of students, mistakenly think is that STEM OPT is not sponsored. Well, in reality, STEM OPT is what we call like a light sponsorship. So there is a sponsorship by an employer. The employer, as I mentioned, is required to be enrolled in E-Verify and a member of its standing. And also that employer is responsible for assisting with completing that training plan and ensuring that it is adhered to. And then with the E-Verify, we just wanna make sure that employers, they have to be an employer in good standing, right? They have to make sure that they are actually using E-Verify, using it properly, and are in compliance with their E-Verify memorandum of understanding. Okay, next slide, please. So these site visits, right? What's happening with a site visit by SEVP? So this is for ICE to come in, ICE, which oversees the SEMOPT extension. ICE is coming in order to review the audit file. And there's an audit file that an employer is required to keep. Again, this is where the sponsorship comes into play because there is obligations and liabilities on the part of the employer. So this audit file needs to be maintained by the company with this specific information and documentation that we'll talk about. An ICE officer comes to the site. The person who's there at the front desk or the main point of contact always, always, always should confirm the identity and credentials of the investigator. And then likely if that person is in charge of dealing with the ICE investigator, otherwise contact the individual within the organization who's going to be the point person. And within the organization, whoever is that point person, they need to make sure that they have this audit file intact and they're prepared to present it if requested. So they're going to need to provide documentation that's related to the E-Verify account, the employee's job information, and then that I-983 training plan detail and the confirmation that that is, in fact, in existence and is being adhered to. Okay, next slide, please. Right, so what is an officer going to ask for? And this is in line with the audit file. So the officers are going to want to see the I-983 training plan. They want to see proof of the company's enrollment in E-Verify. They want to look at the employment records for the F1 student, which will include their job description, their hours worked, and their salary. And again, they're going to be comparing this to what is stated in that I-983 training plan. Also, there's going to be evidence of compliance with this training plan. And as some of you may know, with the training plan, there are a series of evaluations. There's one halfway through the STEM OPT extension at that 1 year mark. And then there's an evaluation at the end of the STEM OPT. So the officers are going to look to make sure that those evaluations have been completed, or at that particular point in time, there's only one evaluation because it's midway through the STEM OPT. And then they're also going to look, they being the officer, to ensure that the individual who's in F1 status on the STEM OPT is working in a field that is directly related to their field of study. And that's really important. So if anything changes during the course of this STEM OPT extension, it may require an amended I-983 to be submitted to the DSO. And that's something that can be, talked with an attorney. I do see a question here about, are the visits scheduled or random? They typically tend to be random, and the ICE officer will typically show up at the work site that's listed on the 983 training program. So that's what we have with some OPT extensions. I'll turn it over to you, Carrie, for the amazing FDNS site visit actions, which are happening right now.
Thanks, Kimberly. Yeah, one of the things I wanted to reiterate about what you said is STEM OPT or I-983 process being, sponsorship light. We call it sponsorship light because uh, employers are not doing the petitioning, right? Employers are not submitting petitions. But you should never think that you're off the hook in connection with submitting an I-983 or bringing on a STEM OPT worker. Because as Kimberly said, these investigations are happening, and I'm going to talk about FDNS, fraud and detection site visits, which are in connection with USCIS or USCIS investigations. But these ICE SEVP investigations are done by ICE, Immigration and Customs Enforcement. And so it's actually a much more serious investigation, in my opinion. um, because with FDNS, if the result is that the officer is not able to verify or there are some discrepancies, the employer will receive a notice of revocation. But in an ICE SEVP investigation, the consequences could be much more serious. And so it's just very important that employers take seriously STEM OPT, quote unquote, sponsorship, because the consequences of not really digging into the I-983 training plan and making sure that it's absolutely accurate in terms of what is expected of that student work, are pretty dire. So, and the other thing I wanted to mention is the audit file. Typically in immigration, when we talk about audit files, we're talking about I-9 audits, we're talking about DOL audits with public access files or perm audits. But in this day and age, in connection with immigration and immigration program management, you need audit files for everything. So all of the petitions that you file to USCIS, you want to start organizing those and collating them if you haven't already. So making sure you have an electronic file where you can go easily pull those. Don't leave it to the foreign national employee. You don't want to be running after the employee saying, "Hey, can I have a copy of your petition?" And then also with these I-983s, you want to have them handy to pull. And any other immigration sponsorship, you want to make sure that you have documentation readily available as part of your plan. With FDNS site visits, these site visits are intended really to confirm the information that's in a petition. So again, be prepared, be prepared, be prepared. Have your FDNS audit file, which will contain a copy of the petition at minimum, because literally the FDNS officer is just paging through that petition and looking to verify the information contained therein. And if there are any discrepancies, um, probably will issue a notice of intent to revoke. It's like an RFE, but a little more serious, and you have to respond to it. Train HR and anybody else handling FDNS site visits so they're very well prepared to respond. Again, retain audit files And it's a good idea to bring in your immigration attorney. So typically with an FDNS site visit, you'll get a list of questions as a follow-up after the FDNS officer appears on site, or if they're doing it remotely, they'll just do it via email. You always want to forward that to Immigration Outside Counsel so they can look at it, and also so they can check your answers before you submit your response. If you do not do these routinely, you definitely want help. You can go to the next slide. So why does USCIS fraud detection conduct these site visits? Well, it's purely to verify the validity of the information submitted in the immigration petition, which is non-immigrant typically. Your H's are the primary focus, but also L's are investigated and other types of NIVs. And then confirm that employers are not using visas in a fraudulent manner so that your H-1B worker is working at the site contained in the petition and not, let's say you're in the Bay Area and not in Columbus, Ohio, which has a much lower prevailing wage rate. This is all about keeping employers in line. You can go to the next slide. So what does an investigation entail? Uh, USCIS fraud detection officers will want to review any kind of documentation in connection, well, in really to verify the information in the petition. And this often boils down to the wage. How much is the individual earning? So they'll likely ask for W-2s or wage statements and other petition details. They'll ask about the company's operations. They want to know that a legitimate company filed a petition. And this is fascinating because even the largest enterprise multinational companies, household names, receive these FDNS site visits where the officer is saying, please, explain to me what you do as a company, even though I have your products in my home. They're always asking, they always want to verify the legitimacy regardless of how well known the company is. So don't be surprised by that. These officers will also want to take a tour of the premises. Um, they'll want to talk to the person who signed the petition. They'll want to talk to the person who manages the employee, and they'll want to talk to the employee. So those are the three primary stakeholders that FDNS will want to engage in these site visits. We can go to the next slide. So, what do you do to respond to one of these investigations? As Kimberly mentioned, number one thing in any kind of investigation is to verify the identity of the investigator. We do not want to be responding to vigilante investigations. And I'm not saying we've seen this, but there is opportunity. I mean, I think that there's a certain amount of caution. I don't know if I would say fear, but there are individuals who are taking advantage of the situation right now, masquerading. So just make sure that you're verifying the investigator's identity. Reach out to counsel so that we can help you through this. There are some in-house program managers that have done, dozens, if not hundreds of these FDNS site visits. But if you're new to this, you definitely want to get immigration counsel involved. And we can even participate in a conference call. We can even be available when meeting with the investigator from time to time. So you may consider that. Ensure only knowledgeable staff answer questions. You really don't want to get somebody pulled into one of these investigations that is not very familiar with the petition in question. Um, and usually an investigator interviews the employee, the manager, and the person who signs the petition. And so you just want to make sure that you're well prepared. Uh, Having a written policy or some type of step-by-step manual is a fantastic idea. So your staff are not caught off guard. We can go to the next slide. Examples of questions, and I will say we have some FDNS site visit role-playing videos that go through all the different types of H-1B petitions, from change of employer to amendment, to third-party placement because these are being scrutinized heavily, and then even as Kimberly talked about these. I-983 site visit. So we have role playing videos. If you think that your staff would be more comfortable training on role playing videos, we're happy to share those with you. They're a little embarrassing, but they get you get the picture.
Good actress, Carrie.
Um, and those role-playing videos will go through these questions and how to respond to these questions. So how is the employee supervised? That would be asked to the direct manager and or the person who signs the petition. Is the supervision offsite or onsite? We do expect this issue to be very prevalent in requests for evidence and site visits, third-party placements, um, the employer-employee relationship. So you need to be very clear on how sponsored employees are supervised. And this is a training point for anybody that's handling FDNS site visits, training them on how to answer questions in connection with supervision. Who controls the work? That's again aligned with the employer employee relationship. The tools and instrumentalities, again, employee employer relationship. The Neufeld memo, I memorized it back in 2008 or 2009. I can't get it out of my head, but this is a big primary issue, the employer employee relationship. If you have third party placements, you need to be prepared for a site visit. And then who evaluates the work product and the specific job duties. All of these things are contained in your H-1B petition and will be investigated by an FDNS site visit officer. Let's talk a little bit about best practices. Um, you really want to, again, verify the identity. Take their business card. They still carry around business cards. Connect with them via email immediately if they show up in person. Ask them for their email address and just send them an email so you get them in your Outlook and whitelisted so you don't miss any spam. I've had clients who have just missed these investigations because the officer's email goes to spam and then they get a notice of revocation, and very surprising.
Can I jump in and ask you a question that just popped up here because I think it's super relevant? If they're given a business card, right, if it just has their name and contact number information on it, how does a person at a company know that it's legit?
This is a great question, and the way that I always do this is to make sure that it has a .gov at the end of the email. There needs to be a .gov, and then uh, to use that email address and make sure it's legitimate. If there's no .gov in the email address, it's not a real investigator. If they don't have an email address listed on that business card, then I would also be very suspicious of that. But I think let me take a step back because we're not seeing a bunch of fraud or a bunch of impersonations of investigators, but there is opportunity for that, and so it's just the primary thing that we do first is verify the identity. But sometimes these investigations look like scams. And when in doubt, reach out to Kimberly and I will help you confirm.
Well, and one of the other things we also see as well is just recently within our own firm, there was an FDNS site visit here in San Diego with one of my colleagues' clients, and they reached out to me to say, "Is she legit? Like, this is this right person?" I'm like, "Oh yeah, she's the officer down here. We see her all the time." So there's also, as you said, Carrie, reaching out to the attorneys because most of the attorneys, if they aren't in that particular area, they know a colleague who is in that area and can help, verify that that person is legit, that they see their emails and their requests for information all the time.
And, a quick Google search or a LinkedIn search, government employees do not, advertise themselves on different platforms, but they typically will have a quiet LinkedIn profile. So you should be able to verify them, through a quick Google search. If the employee is working at a client site, you want to be paying special attention to that individual, and contact the end client to make sure that they're prepared in connection with any kind of site visits. Make sure that your employee has a redacted copy of the petition. If you don't want to share your financial details with the employee, you can redact that out. but the employee should be conversant in terms of what is contained in that petition, so they're not surprised by any of the questions that the FDNS officer asks. Um, you want to make sure that an investigator isn't exposed to sensitive areas in your workplace. They'll ask for a tour, but you want to keep that contained as much as possible. And again, be prepared. You don't want to be guessing at answers. You want to have reviewed the petition in question. No need to memorize it, but definitely read it 3 to 5 times, so you understand what the officer is getting at. Um, never let an investigator wander around on premises without an HR or well-trained individual accompanying them. And also taking notes about what that investigator is looking at or asking questions about. Um, any derogatory information that is presented while an investigation is taking place will be used against a petitioner, um, to trigger a notice of intent to revoke or a notice of intent to deny. So, again, it's important to be familiar with the petition and to truthfully answer all questions. You don't want to get in a situation where, you're guessing or, you're making things up on the spot, because that certainly will be used against you. And less is more. I mean, we always encourage in any kind of investigation or interview to answer with brief and honest answers. Do not overshare. And so that's another reason why role playing, FDNS training is very helpful, because it will prepare the HR individual or the primary point of contact or the person who signed the petition to deal with the investigation. Uh, this may be a little bit hard to read, but it's a FDNS site visit map. First verify the officer's information, then notify your designated point of contact or attorney. You always want to meet with that investigator in a private room first. One, not to alarm for other colleagues, and then two, to exchange information. Inform the employee and provide guidance to the employee. Again, at minimum, provide a copy of the petition to the employee. And then the investigator will conduct an interview, and you'll want to take notes. You want to try to be present at the employee's interview and or ask the employee to take notes, and their direct manager. After a site visit is complete, you'll want to review and document any questions, especially if there is any information that was shared with the officer that does not align with the information that was in the petition. Then you will need to be prepared to receive a notice of intent to revoke or a notice of intent to deny, which will need to be responded to. It can be overcome, but it is very serious. And then ultimately, you will conclude the visit and escort the officer out. They will be following up. They will be following up with email questions. Typically it takes a few weeks to conclude these site visits. So there's always follow up afterwards. We can go to the next slide. So we'll move on to DOL investigations, and just a quick reminder, feel free to put questions in the Q&A. And, with the FDNS site visits and the DOL investigations, we're talking about your non-immigrant visa. So if you are an immigration program manager and you're filing a handful or hundreds or thousands of non-immigrant visas annually, uh, this is where your primary concern is, in addition to I-9 investigations. But we certainly do expect FDNS site visits to audit your H's, your L's, your other petition types, and then Department of Labor investigations to audit your public access files, your perm applications. If you're an H2 filer, your DOL documentation in connection with that H2, and then those also are results in wage and hour audits, or they're part of wage and hour audits as well, which I'll talk about. Um, so regarding the public access file, First thing to do is just to review your document retention requirements, right? And if you have any public access files that are past the retention date, get rid of those. You do not need to keep public access files in perpetuity, and you should absolutely purge public access files that are beyond the retention date. And that would be 1 year beyond the date of termination. And so, oftentimes employers will keep public access files, even though they have extended petitions for individuals, and those public access files are for legacy H-1Bs that may have been filed 5 or 6 years ago. Get rid of those. When you store your public access files, you do not want any PII, personally identifiable information. We recommend using the LCA number and then creating a key to match up the number to the foreign national employee. The Department of Labor doesn't need to know the names of the individuals in the public access files. They are just auditing the public access files, and removing any PII will also limit the exposure for the employer. Payroll records of foreign national employees um, should be retained for 3 years. And, oftentimes the Department of Labor will be auditing, or any kind of investigation typically includes audit against payroll records or W-2s or other payment records. Um, you want to make sure not to destroy any documentation that is currently being audited or investigated, even if it's beyond the retention period. This could result in extremely serious consequences. You can go to the next slide. So, how does the Department of Labor conduct a PAP audit? One thing I want to mention here is that a Department of Labor audit is different and distinct from a member of the public requesting access to public access files, right? Oftentimes we think about public access files in the context of making them available to anybody in the public who requests access. And that's a requirement, it's a compliance requirement that they are available to a member of the public within 3 days. But when we're talking about a Department of Labor investigation of an H-1B E3 or H-1B1, we're talking about the Department of Labor asking for documents, including the LCA, the public access file, the petition that was filed, payroll records, W-2s, I-9s. They will supply a laundry list of items. And what they're really dialing in on typically is the prevailing wage, and whether the prevailing wage was met, and whether the foreign national employees are being paid that prevailing wage, whether the employer is compliant with where they're placing that foreign national employee. And in addition to that, uh, whether or not any wage and hour laws have been violated. You cannot put an H-1B worker in non-productive status. You cannot, quote unquote, bench them. You cannot furlough them. Full stop. If you furlough, bench, or put them in unproductive status, you will get dinged. And that is really, I would say, the number one thing that the Department of Labor is looking after in connection with public access files. Auditors may interview employees. They certainly will interview employers, and outside counsel should always be involved and assisting in connection with the Department of Labor investigation. These are not things to ignore. Ignoring these will result in potential back wages to be paid. Um, Fringe benefit reimbursements to be paid if those haven't been paid. The nitty-gritty is civil monetary penalties, and I believe that, um, the penalty can be as high as around $30,000 for DOL violations in connection with public access file, deficiencies. And then prohibition from obtaining any new non-immigrant or permanent program for workers. And this is debarment. And we do see employers debarred for misusing labor condition applications and other types of labor filings. I'm going to spend a little bit of time on H2s before I transition it back over to Kimberly. We can move to the next slide. Um, for those of you who use H2s, whether you be in hospitality or maybe golf courses or agriculture, wage and hour audits are probably the most cumbersome type of immigration investigation in connection with a non-immigrant visa, and they're primarily targeted to H2 employers. And so the Department of this is a wage and hour investigation when Department of Labor comes after an H2 employer with an audit. And they're looking at wage rates, they're looking at bonuses, incentives, they're looking at tips. If you're in hospitality and you're paying tips, how you're paying those tips. And if they're deducted, only lawful recorded deductions that were presented in the H2 labor condition application can be are permitted. And then hours worked, if overtime is worked, that better have been included in the labor condition application or the labor certification. Job accuracy, verify job offers are correctly state wages, deduction hours, and work sites, and also housing and transportation. These are major audits, and they usually are run over the course of months. And the consequences of not being compliant again are debarment and very high penalties. We can move to the next slide. Oh, sorry, we were not in. Yeah, move to the next slide, please, as well. So for non-compliance, an employer will face financial penalties. Sometimes we can negotiate them down, but they are significant. And it's either typically as a result of information presented in the labor certification was inaccurate and not actually in practice. But watch out for corresponding employment. If you're bringing temporary workers in and there are permanent workers in similar occupations or the same occupation in a corresponding occupation, and those corresponding employees are not treated exactly the same as your H2 employees, you will be penalized for it. And this is a really huge area of exposure. So you want to make sure that if you're sponsoring housekeepers or experts, or however you are dealing with your seasonal or peak load needs, that your permanent workers performing in those same occupations, or your temporary workers who are domestic workers. It's really temporary workers who are domestic workers who are at issue here, are treated exactly the same as your H2 employees. Um, Back pay is another huge thing, also aligned with H-1B. Department of Labor wants to make sure that employers are meeting their wage obligations. Again, you cannot bench, and you have to pay for overtime. And then, of course, larger penalties and fines for failure to pay wages will be levied in addition to any back wages. Misclassification of employees, again, corresponding employment, and definitely making sure that you are compliant means reaching out to your outside counsel. Debarment is a reality. And I have, again, had clients who have been somehow unaware that a wage and hour audit is underway and maybe didn't like the format of the email. Maybe the email went into spam. Couple months later, they get a notice of debarment, and then we're scrambling to respond because actually the wage and hour audit was never engaged. So just make sure that if you receive anything from the Department of Labor, that you take it seriously and you spring into action and that you have a plan. All right. I am going to hand it over to Kimberly, and I think we're going to try and do Q&A at the end of the Kimberly and her kitty cat. Kimberly, what does your cat have to say about IER?
Yeah, he's the real expert. He won't leave my side, so I'm just loving him. He's gonna whisper the answers into my ear.
We'll play tunces. He can tell us what's going on with IER.
There we go. He's my crystal ball. All right. So, IER Investigations. This is the Immigrant Employee Rights section of the U.S. Department of Labor. So, these investigations are on the anti discrimination side of I-9 compliance. So, for I-9 compliance, we have 274A and 274B. The one side deals with the actual enforcement of how the I-9s are completed, what is permissible documentation for work authorization, et cetera. And then the other part of the statute deals with the discrimination that may be conducted by employers during that I-9 or E-Verify process. So IER can do these investigations. Either they're complaint initiated, meaning that an employee says, hey, the employer discriminated against me. They didn't accept my permanent resident card, or they told me to produce specific documents, or they didn't hire me, or they terminated me, etc. IER initiated is just that. IER can open up its own investigation. And they have done this many times. They might do research on the internet to determine if there's something ongoing by a particular organization or an industry that is running afoul of the anti-discrimination provisions of the statute. So during an IER investigation, whether it's complaint driven or IER initiated, all I-9s for active employees and sometimes terminated employees as well are subject to being reviewed by the IER investigator who is an attorney. The investigators at IER are typically the attorneys. So the IER investigator attorney will not only review the I-9s, but will also interview the managers, the employees, and the owners of a company. This is a much thorough investigation typically than an I-9 notice of inspection when an audit is conducted by Homeland Security Investigations. And the IER investigations can literally last months or many years. An I-9 audit, the notice of inspection, can also last months or years, but usually with HSI, the auditor will gather the I-9 documents and the other supporting documentation, and then they'll go back to their office, they'll review everything, and they might pop up months later with a notice of technical or procedural failures. With IER, these investigations can actually be ongoing for months or years at a time. So there's constant communication, there's scheduling of depositions, of interviews, et cetera, wherever their investigation takes them. So it tends to be, as we see, sometimes a lot more intrusive than what you would see in a typical I-9 audit. Okay, next slide. So what is I-9 discrimination, right? So they look at 4 things that are prohibited. So there's citizenship status discrimination in the hiring, firing, or recruitment or referral for a fee of employees. There's national origin discrimination, again, in hiring, firing, or recruitment or referral for a fee. There's document abuse, and that is unfair documentary practices. But typically, what this means is an employer asks for more documentation from an employee than is required to present, or an employer asks for specific documents of an employee while completing the I-9 process. That is what is considered document abuse. And then the fourth ways that discrimination can pop up is with retaliation or intimidation, meaning, and this happened in an investigation I did years ago, there was an HR manager who was not very good at her job. And so she was going to be fired, and she filed a complaint with IER. And then after she was terminated because she was not performing her job, the employee then alleged retaliation because of the complaint filed with IER, as well as retaliation against her because she was only doing her job with the I-9 compliance. But in reality, what was happening is that she was actually engaging in document abuse. So that's one thing where you can see retaliation or intimidation, either because someone speaks up to an employer and says, hey, there's a problem with the I-9s, or someone files a complaint and then they're terminated or retaliated against. Okay, next slide, please. So I-9, we have the anti-discrimination provision, and one of the ways that discrimination pops up is with document abuse. So we always like to talk about document abuse in terms of what not to do. So never ever request documents before hire or during an interview. Now, there might be certain circumstances in which, for business operations purposes, you're evaluating the sponsorship requirements of a particular foreign national. And again, talk with counsel before start asking for certain documentation. But this is primarily where an employer might say, well, I want to see your EAD card because they want to determine in advance how long the person has to work, and then take action from there. So, like I said, there are certain reasons where there might be a business operation reason for asking for certain documentations to determine sponsorship. And then there's other instances where an employer might just be asking for documents just to pre-verify, and that would not be permissible. An employer cannot specify which documents to accept. So it's always good practice to provide the employee with that list of acceptable documents and tell them they need to choose a document from list A or a document from list B plus a document from list C, right? So never, ever, ever say, let me see your passport or let me see your driver's license and social security card. Always provide that list of acceptable documents and allow the employee to provide the documents. Again, don't require more documents than necessary. One of the things where we do see employers sometimes get tripped up is if an individual checks off in section one that they are a permanent resident, the employer cannot ask, let me see your permanent resident card, right? The employee can choose to present that as a list A document for identity and work verification purposes, or they could choose to present an ID from list B plus maybe their unrestricted social security card. So never ask for documentation just because of what the employee lists in section one. And then don't refuse to honor acceptable documents. And this has happened with some employers where they're like, no, I don't want that document. That's TPS. I don't think it's extended. I'm not going to accept it. Employers do have an obligation to do their due diligence to determine if a document is acceptable. And then this is what I just talked about, where don't ask to see a document from section one attestation, right? So that's what IER is looking at in terms of document abuse. Okay, next slide, please. Another area that creeps up and does show up in IER investigations is over documentation. So when ICE, Homeland Security Investigations, is reviewing the I-9s during an I-9 audit, if an employer has a document written down in list A, B, and C, ICE is just going to look over it. But IER will look at that as over documentation, which can be considered discriminatory. So you want to, if there's any kind of over documentation, if you're doing an internal audit, look to see, have employees that are responsible for the I-9 process asked for additional documents, or maybe if they haven't even asked for additional documents, are all these documents listed in A, B, and C on the Form I-9? Or is there a list A and a list C document? So look for patterns during an internal audit and determine, is that just a blip that happened, or is that something that the person who's completing the I-9s on behalf of the company is doing regularly on a routine basis? And then make sure to train that person appropriately. You want to remediate non-compliant forms. So that might be looking at them and up, there's an A, B, and C, or there's an A and a C. Well, the A is a full list A document, but the C is, extra. What can be done, for paper handwritten forms is potentially crossing out the information in list C and initial and dating it so that it's clear that the employer recognized that this was not necessary. Create an organization-wide non-discrimination policy with respect to your I-9 process. And then again, always have training and refresher courses for your employees who are responsible for that I-9 process. So we advocate lots of training, especially with how many changes there have been recently with I-9s. Right, next slide, please. Right, some unfair documentary practices that we've seen. So there was an IER investigation that determined an agricultural company had re-verified the work authorization of lawful permanent residents who had already provided documentation to prove that they had unrestricted work authorization. So IER determined that that was a discriminatory action on the part of the company. They received a civil penalty of several $1,000s. They were required to conduct training of personnel, and they were monitored by IER for 2 years. So that's what that investigation resulted and with the employer asking to re-verify work authorization. Next slide, please. And then there also has been IER conducting investigations and looking at discrimination in software technology. So I know we're a little bit limited on time here. So the overall gist of this is that one of the big cases from a few years ago, which is a really good example, is with Georgia Tech. So IER ended up investigating multiple companies that had used a platform that was operated by the Georgia Institute of Technology, Georgia Tech. And in that platform, where employers were advertising jobs, they didn't realize that there was actually a drop down box. And so a lot of employers did not select the appropriate item in the drop down box. So it looked as if they had a discriminatory job ad. So what happened is that some qualified students were refused or couldn't apply because they were not US citizens. And that resulted in a discriminatory practice. Inadvertent as it was, IER said that the employers themselves are liable for the discriminatory action, even though there may have been a defect with respect to that software platform. So, the moral of the story, so to speak, is that as an employer, if you're using a third party platform for any type of recruitment or ads, make sure that you are vetting that appropriately, that you are looking through it and making sure that there's no inadvertent discriminatory actions that are taking place with the way that software is training things or asking for information. So, bottom line is that an employer is still liable, even if you don't have direct control over that. IER expects an employer to say to that third party platform provider, hey, there's something wrong with this. You need to correct it. Right. So that's one thing to just stay on top of. Okay, next slide, please. And these are the settlement agreements. And if for those of you who don't know, you can actually subscribe to Department of Justice IER to receive information about these settlements and investigations that occur. So you can see them as the settlements come about. So the largest fine here was with KPMG because they had the most number of ads that they utilized on our platform. So that was over $306,000. And then the smallest settlements were about $4,000. One of the things that happened is that IER can kind of strong arm employers into these settlement agreements as opposed to going to litigation, which can get extremely pricey. All right, next slide, please. And then electronic software programs. There has been a settlement, or there was a settlement between IER and Securitas Security Services, in which IER said that there was a situation where the employer required permanent residents to provide a permanent resident card as part of how that software program was developed. And what was happening is that if an individual selected that they were a lawful permanent resident, this software program then said, oh, you need to provide a permanent resident card. So again, be careful with electronic software programs. Make sure that you vet them and use, your counsel to vet them as well so that you are not put in that circumstance where you can be accused of discriminatory practices. That's IER in a nutshell, and we'll talk more about those investigations on April 15th. And we have 2 minutes left, so I'm going to turn it over to Carrie to wrap up with some best practices and anything else that we wanted to cover.
Thanks, Kimberly. Yeah, it was a lot of content here today. And so we're going to really tease this out and get into the nitty gritty of what to focus on April 15th. But in terms of best practices, I would just say prepare, 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 prepare. Now is the time uh, because we have seen a surge. The Attorney General issued a memorandum on, I believe it was February 5th, specifically citing immigration investigations and prosecuting to the furthest extent of the law. So this is very serious. Train, audit. Now is the time to audit. If you haven't done it in the past 18 months, get it done. If you have done it in the past 18 months, do it again. Create standard operating procedures on how to respond to FDNS site visits, DOL audits, IER investigations, and I-9 audits. And again, perform routine internal audits. Perform role playing, practice, go through drills so you're very well prepared. And then, for employees, you can steer them toward know your rights guidance. A lot of immigration projects and pro bono organizations have know your rights cards and know your rights materials. I will say that employers need to draw the line in terms of what you can do for your employees, because at the end of the day, if they're not authorized to work, they need personal counsel unless you are sponsoring them. We're at time. This was wonderful. We put a lot of answers in the Q&A, and please join us on the 15th for follow up and to tease out some of the issues that Kimberly and DOJ leadership discuss in early April.
Right. And we'll also touch on harboring, which is becoming, as Carrie mentioned, the February 5th Attorney General memo that is going to wrap into enforcement actions as well. So thank you, everyone. Thanks, Carrie.
Thanks, everybody. Have a great day. Thank you. Bye bye.
Bye. Take care.